Group lotteries are known to be great in increasing one's chances of winning the jackpot, but there have been several cases of betrayal at the point of winning that might make you never play the lottery pool. Here are 10 lottery pool cases that prove you should never play the group lottery. Number 10. Tonda Dickerson. Tonda Dickerson was a waitress at Waffle House, Grand Bay, Alabama in 1999, when a customer, Edward Seward, on March 6th of the same year, tipped her and 4 other restaurant workers with lottery tickets he bought in Florida, because lottery tickets were illegal in Alabama. The next day, the winning lottery number was announced, and Tonda realized she had won the jackpot of about $10 million. She was the only one in the group whose ticket won. She was over the moon as her life was about to change. She chose to receive 30 annual payments of $375,000 instead of taking a lump sum payout of $4 million. Her coworkers were excited for her and for themselves. They expected Tonda to share her winnings with them, claiming they all had an oral agreement that if any of them won the jackpot, they would split it with the rest. But Tonda said she had no such agreement with them. Shocked and unable to get her to comply, her coworkers resorted to court and filed a lawsuit against her in Alabama court. Within 45 minutes, the court ruled against Tonda after a couple from the restaurant testified against her, saying she had told them about the deal she made with the rest of the waitresses. Tonda refused to accept the court's ruling to keep $3 million. Eventually, in 2000, the Alabama Supreme Court overturned the first ruling on the grounds that the deal Tonda made with the others was a form of illegal gambling. The court found out that there was no official contract, and the Alabama law stipulated that contracts related to gambling, which is illegal, are not enforceable. Tonda won the case. Then came Edward Seward, who gave Tonda the ticket. He was not only displeased that she refused to share with her colleagues, but also refused to buy him the pickup truck he claimed was agreed upon if any of the employees won the lottery. He sued Tonda, but his case was dismissed by the court. As you can see, oral agreements don't always hold up. Tonda made away with the whole amount of money. So what do you think about this story? Who do you blame for the bad outcome? Tonda, the coworkers, or Edward? Please tell us in the comments as we progress. Number 9. Americo Lopez. The case of Americo Lopez was a popular one that's quite a cautionary tale. Americo and his coworkers in New Jersey always pooled their resources together to buy lottery tickets. Americo was the one in charge of buying the tickets and checking the winnings. When, in November 2009, Americo checked the lottery result and found out their ticket had won a whopping $38.5 million, he quietly quit his job on the basis that he needed foot surgery. However, in 2010, he confided in one of his coworkers, Daniel Estevez, that he had won a lottery after leaving his job. Daniel alerted the others, and they investigated and found out on the Mega Millions website that Americo had won the lottery during the time he was still with them. They found out he was hiding the ticket from them. Confronting him, he said he had won the lottery with his private ticket. Not convinced, his 5 coworkers took him to court. In 2011, as the case was gathering momentum, the judge had the lottery money frozen, but by then Americo had already spent a total of $5 million from the money in buying houses and making cash gifts to family and friends. Based on evidence and arguments of his coworkers, the jury in State Superior Court in Elizabeth, New Jersey, ruled against Americo and awarded each of his coworkers $4 million of the lottery money. They just wept in joy that finally justice prevailed and greed was conquered. Would you like to go through that much stress after winning a lottery? I'm gonna guess not. Number 8. John Piccolo. In 2004, John Piccolo played Mega Millions with his coworkers at Mount Sinai Hospital, Manhattan. In November 2004, John won $175,000 with a ticket his coworkers, Veronica Edmondson, Denise Beaulieu, and Joan Pitkin, claimed came from their office pool. When John called Edmondson to inform her something came up and he would be late for work, saying, "I just won the Mega Million second prize for $175,000, Edmonton was overjoyed. According to Edmonton in court papers, she was excited and told him, "We won, John," to which he replied, "No, I won." That was when they knew they had a problem on their hands. When John insisted that he had bought the winning ticket with his money, his coworkers took him to court. The Manhattan judge presiding the case froze John's account, but by this time, he had already spent about $28,000 out of the $109,000 he had gotten after taxes. The case proceeded. The coworkers claimed John had bought the winning ticket with the $3 the group had won the previous week, which they had all agreed to use to buy new tickets. John's lawyer, Thomas Weiss, claimed his client bought the winning ticket from his own money from a store close to his Queens home. According to his lawyer, John always bought separate lottery tickets for himself in Queens that were separate from the ones he bought with his coworkers in Manhattan. Evidence that the $175,000 winning ticket was his own. But Justice Marilyn Diamond found the claims of the coworkers more believable and ordered for the $81,000 remaining lottery money to be frozen while the case was on trial. The case was eventually resolved without going on trial, but the settlement wasn't made public. Are you a member of a lottery pool? What measures are you taking to prevent misunderstandings? And if you're a leader of a lottery group, what are you doing to be transparent to avoid issues that touch the heart? Please let us know in the comments. And take a moment to hit the like button and subscribe. Let's continue with this amazing cautionary tale. Number 7. Stephen Kyle. When Stephen Kyle, a postal worker in Ohio, tricked his coworkers after their pool tickets won a $175,000 jackpot, 6 of his coworkers sued him in court. How did it all start? Well, Kyle, 51, of Amherst, was in charge of buying tickets for the office pool. In 2004, Kyle picked 5 of 6 winnings in the Mega Millions jackpot and later destroyed the pool tickets. Then he failed to make copies, which was contrary to his normal behavior. He allowed 5 days to expire before telling his colleagues he had won. He insisted he had bought the winning ticket with his own money and not the office pool's money. He claimed he also bought the tickets 2 days before the winnings instead of 1 day. However, the lottery records and a store clerk contradicted Kyle's claims, yet he insisted on his own narrative. The jury presiding on the case said they didn't believe Kyle's story after seeing evidence. Kyle claimed he had bought $100 worth of tickets for the pool, but the lottery sales records showed that he had bought $50, as against what he said. It was 6 Ohio postal workers who sued Kyle for part of the $175,000, but the court ruled that all 20 lottery pool members, including Kyle, will split the winnings equally after the jury decided that Kyle was wrong to have kept the jackpot to himself, cutting his colleagues out of their rightful share. Each person would receive $8,750 before taxes. Efforts were made to settle the dispute outside of court, but certain concerns over further litigation made everyone decide to hash it out in a court of law. Phew, that must have been cumbersome. How one person's greed tries to take away the joy of winning. Number 6. Lou's Creative Styles. Back in 2013, some stylists at Lou's Creative Styles accused their colleague of trying to cheat them out of the $9.5 million winnings from a February 16, 2013 jackpot. Court documents revealed that the 8 workers regularly contributed $5 each to purchase Hoosier Lotto tickets. The document asserted that the woman had an agreement that whoever bought tickets for the group must not buy tickets for themselves from the same place. This was a measure they took to protect themselves from any inconvenience or mischief. But the woman who purchased the tickets for the group that week claimed that she used her own money to buy the winning tickets separately from the tickets she bought for the group. The lawyer representing the women being denied their fair share explained that the woman who bought the tickets told them, "You didn't win, but I did." 6 months after the jackpot was won, in August 2013, the case was eventually settled in a confidential agreement. Thank goodness it was finally settled, but the stress of the trial and the shock of the betrayal have been too much for every one of them. Number 5. Edward Hairston. In 2011, a worker sued 22 of his coworkers after he was left out of their lottery pool win of $99 million. Edward Hairston found himself in pain when he was cut out of the lottery pool jackpot after participating for 8 years. What really happened? Well, Edward, native of Youngstown, Ohio, was not able to come to work for June, July, and August due to a back injury. The group collected the 6 correct numbers in a Mega Millions draw, which was to give each of them about $2 million after taxes. The next day, Hairston landed in Craftmate in Milton, Ohio to claim his share, but he was informed he wouldn't be part of the winnings because he hadn't contributed any funds to the pool for 3 months. According to Edward's lawyer, Howard Mishkin, the group had an undocumented policy for years to accommodate a colleague who was out because of vacation, illness, or some other reasons. He pointed out that Edward had in the past made payments on behalf of another member who was absent on a medical leave for 5 months. The lawyer, Karen Lynn Kaminsky, representing the other 22 co-workers, explained that the decision of excluding Edward from the jackpot was not personal. She revealed that 2 other colleagues who participated in the July lottery pool but didn't join in August had not sued the group, as reported by abcnews.com. Kaminsky stated that the plaintiff didn't participate in buying lottery tickets for 3 months, and even after being invited through email, he didn't come forward, and because of that could not be a winner. Mishkin countered this claim, saying his client couldn't access the information because the email was sent to a work address as he was away from work. A judge at the Cuyahoga County Common Pleas Court then ordered for a part of the jackpot to be withheld by the Ohio Lottery Commission pending when the lawsuit was resolved. Eventually, the case was settled in January 2012 on confidential terms, as reported by Cleveland.com. Do you think it's right to include Edward in the jackpot? Let us know in the comments and keep watching. Number 4. The Dirty Dozen. It's always overwhelming to win millions, so when a group of 12 coworkers at Pita Pan Old World Bakery in Chicago Heights, Illinois, won a $118 million jackpot in 2012, they felt out of the world. It was a wild dream come true, and they called themselves the Dirty Dozen. But their joy had a stumble when 11 of their colleagues came out and claimed to be part of the lottery pool that won the jackpot, and demanded a cut of the cake. Chicago attorney Michael Ha knew he had a huge dispute coming up after he met his 12 clients at the Illinois Lottery Office to claim their $118 million jackpot from the May 4, 2012 draw. When the legal battles erupted and a total of 23 employees and 6 firms got involved in the legal battle, it wasn't easy for anyone. For the next 2 years, the case was on trial, with the other 11 bakery workers insisting that they had helped fund the ticket. One employee's lawsuit insisted that the workers bought tickets as a group. Although that worker's lawsuit accepted that he had last given money for the lottery on March 30, 2012, more than a month before the eventual drawing, it claimed that small rollover winnings were used to purchase the $118 million ticket. Another player rejected by the Dirty Dozen explained that he came to work with great joy after hearing they had won, but they told him, "No, you're not in the group." His attorney, Michael Baird, said being told he wasn't part of the group wasn't the best news. Baird said it was a scenario where everybody was together until there was some real money involved. In its legal filings, the Dirty Dozen insisted that there was no lottery pool that extended from drawing to drawing. They maintained that there were only individuals who contributed to particular lottery drawings. You can see how messy it all went. Well, in April 2014, 2 years after the winnings, the case was finally settled. Illinois lottery records showed that the Dirty Dozen each received $6 million payouts, while 6 others shared $13,840,000. However, the good thing was nobody got a penny while the battle went on in court. The profound lesson here is before you participate in a lottery pool, make sure all guidelines are adhered to by the group to avoid messy legal battles. What do you think? Number 3. Christopher Bates. On January 28, 2011, a group of mechanics and maintenance staff at Bombardier Plant, Ontario, won a $50 million jackpot, with each receiving $1.9 million, including about $2,400 in interest. But one coworker claimed he was excluded from the winnings because he was away on a vacation. Christopher Bates from the Bombardier Plant sued 24 of his coworkers over a $50 million jackpot. He claimed to be a regular player in the lottery pool, but was kept from the winning draw because he was away. In fact, according to him, he founded the lottery pool, and just because he wasn't around didn't mean he should be shut out from the winnings. He contacted his lawyer after he heard of the win and explained his situation to him. However, the group argued that the pool played by no pay, no play rules, which eliminated him from the picture. Christopher was not the only employee who filed a lawsuit, claiming a portion of the winnings. Those who were in the pool but missed that life-changing draw in 2011 also made some claims. It was also revealed that the pool didn't buy tickets regularly, but would arrange randomly to buy when the jackpot hit beyond $30 million. The lottery office had to pause payouts as these cases piled up. In the end, all but 2 of the claims were rejected. At a point, the lottery organization divided the jackpot into 26 parts and held onto 2 of the shares pending the conclusion in the court. A 10-day civil trial was initiated to know if Christopher was entitled to a share. Christopher testified that when he returned from his winter holiday, he approached the group leader, Sharif Morsi, and asked him why he didn't put it in for him. Christopher testified that Morsi said he failed to enter Christopher because another coworker was owing him. Michael Cochran, Christopher's lawyer, argued that his client was a regular participant who also founded the office pool. The fellow group members should have had his back in good faith. The case handled by Judge Carol Brown was finalized on the second day, and a settlement was reached. However, the terms of settlement remained confidential, as reported by Saul Glober, the lawyer speaking for the 24 workers. Do you still want to play in a lottery pool even after hearing that? Number 2. Bell Canada call center employees. On the 31st of December 2010, 19 Bell Canada call center employees won a whopping $50 million. You can imagine their ecstasy. Natalie Damianidis, the group organizer, actually found out they won on the night of January 3, 2011. Their office pool had operated for just 4 weeks, running on a $20 per month contribution. The last $5 bought the ticket that won them the jackpot. Their office building at Brimley and Ellesmere Roads was full of cheers for the 19 coworkers later known as Bell 19, who would become millionaires overnight, 17 women and 2 men. But the story took an ugly twist the next day when 9 other call center employees came forward, claiming a stake in the lottery money, which resulted in the Ontario Lottery and Gaming Corporation freezing the payouts till the disputes were resolved. Their claim was that many of the Bell 19 previously participated in another informal weekly office pool involving around 40 people since February or March 2010, and by forming another group, they acted in bad faith, according to Merrick Tuffman, the lawyer representing the 9 other employees in a statement of claim submitted in February 2011. On Valentine's Day 2011, Ontario Lottery and Gaming Corporation paid the Bell 19 around $1.7 million each in partial payout of their winnings pending the final outcome of the case. Eventually, after 2 years of trial, the court granted the Bell 19 access to their entire winnings, striking out the petition of the other 9 employees. The Ontario Lottery and Gaming Corporation found out that the leader of the Bell 19 group documented the process well and kept a clear record of who paid into the pool. Saul Glober, the lawyer who represented Bell 19, said the judge's decision to dismiss the case was based on if you pay, you're in. If we bought a ticket together last March and I win with another ticket in December, you can't say because we were together in March, I'm your lifetime partner, he added. Number 1. Slavomir Kowalewski. On January 16, 2008, a group of 32 Palco co-workers won $24.5 million. But one employee, Slavomir Kowalewski, claimed he was cut out, and as such, in June the same year, filed a lawsuit against the other 32 employees. Slavomir claimed that he had arranged to be part of the weekly group ticket purchase, but was not included because he was away on vacation in Poland. According to him, he was overjoyed when he heard of the winnings and rejoiced with his family. But when he came back to Barrie, he found out his name had been removed from the pool, and the small green book which had proof of him being a regular contributor went missing. The lawsuit caused the Ontario Provincial Police to probe into the matter, and they found out that the names of the two winners on the list first given to the Ontario Lottery and Gaming Corporation were concealed with white cut. The disputed portion of the Lotto 649 winnings, about $4 million including interest, was withheld in a savings account by the Ontario Superior Court of Justice while the case was being scrutinized. The trial lasted for 3 years, and eventually Slavomir was awarded a portion of the winnings. He was one of 4 ex-Palco steelworkers, Stan Zondervan, Nicolas Limbertos, and Michael Muir, who settled for less than the $4 million allocated for the dispute settlement after the end of the 3-year trial. Marek Tuffman, who represented Slavomir, said his client's share reflects the strength of his own claim, which was considered the strongest. So, what do you think of all the stress of slugging it out in the court of law over a lottery win? After watching the video, do you still want to play in a group or as an individual? Tell us in the comments, and don't forget to subscribe to our channel for more interesting videos. Thanks for watching.